You bet.
We told you a moment ago about the administration's reluctance to say just what it might do if the U.S. Supreme Court tosses out the federal subsidies that help millions of Americans purchase health insurance under Obamacare. What exactly will the justices decide? How could it affect the Affordable Care Act? Robert Bianchi joins us now. He is a criminal defense attorney, former prosecutor. Jay Apt is a criminal defense attorney as well. Jay, let me start with you. I looked up the statute again. It says subsidies go to individuals, quote, enrolled through an exchange established by the state. 37 states didn't do it. So arguably 7 million people are not eligible for subsidies. Do you think the Supreme Court will follow the plain language of what Congress wrote or do something else?
No, I don't think they can follow just by strictly interpreting the statute. There are two important decisions that'll guide the Supreme Court through this. The first is a 1984 decision, which is the Chevron case versus NRDC, and then the follow-up decision from last year, which is Arlington versus FCC, authored by Justice Scalia. And those decisions say that regulators are allowed to use permissible interpretations when there's some confusion in the statute. The confusion here is whether or not these exchanges can be established and funded by the federal government.
Now, the challengers to the White House, Robert, would say there's no ambiguity here. It's the plain language of it. And in fact, if you want to know what Congress intended, go to the guy, Jonathan Gruber, the MIT economist who helped write the law. And he has publicly said, and I looked at it online, it's on YouTube, that we intended for only individuals with state exchanges to get subsidies, because it was our idea then to force those states into going to exchanges. Well, they didn't do it. So, I mean, if they want to know what Congress intended, don't you look no further than Gruber?
No, the Supreme Court is not going to be looking at any of those outside sources. They're going to be looking at the statute itself and the context of the law in its entirety in order to make its decision. I agree with Jay. I think that they're going to be looking at overall what the word state means. It's a very amorphous and general concept. It could include both federal and state law.
Wait a minute, you're telling me state means federal?
Yes, and a lot of times people refer to the government in general as state. State can be both federal government and state government, and this is a very important point. In the absence of them defining more specifically what they meant by that term, it's presumed under the law that if they meant it only to be individual states, then they should have put that in the statute. And I guarantee that's what the Supreme Court's going to say. They should have been more clarified that it was individual states and not the federal government. You
know what, Jay? The White House says, well, it was just a typo, a hasty mistake. Given the fact that there have been 42 significant changes to Obamacare, that probably is true. It was a sloppy law.
Well, it's more than just that. I think the implications are very interesting. I don't think that the Supreme Court will rule with the plaintiffs and overturn these subsidies. But if they did, it would have tremendous impact on the secondary insurance market. What would happen is that the bottom tier that's receiving these subsidies would drop out and no longer be able to pay for insurance. And then the rest of us, our premiums would go up because the insurance companies would have to make up that lag in profits. And basically the effect, if the Supreme Court rules with the plaintiffs, would be that all of our insurance rates would go up.
Yeah, do you think that comes into the equation when, you know, these justices are sitting there, Robert, that, well, we're well into Obamacare. We already upheld it 5-4 in 2012. Can we really now undercut the financial stability of it?
Yeah, absolutely. I believe they will. Remember, constitutionally, they said that the law is valid. This is statutory, which is much less. There are over 7 million people that will be affected by this, over a million that will not have insurance as a result of this. And they're going to look at the overall context of the statute. Scalia and Kennedy, Justices Scalia and Kennedy, have already found that this was constitutional. They will look at the statute now, and they're going to look at the overall impact of it, and I believe it will affect their decision. I don't believe, and by the way, if they even rule in favor of the plaintiffs in this case that the word state only means those individual states, the law still survives.
Jay and Robert, you both are on the same side. You agree the Supreme Court's not going to overturn this thing. You're likely right. Thank you very much for being with us.
Thank you, Greg.
Thank you.